Good afternoon. My name is Attorney Edward Shkolnikov, and today we will talk about very common criminal problem that is called driving under the influence, or DUI, commonly known. A lot of people asking me those questions because they think that DUI cannot be defended. In fact, it can be defended, and it should be defended, and need be defended. Because a lot of times when the people being charged with driving under the influence of alcohol or drugs, they don't even realize that they have two cases going. One case in Department of Motor Vehicle and another case is in California Superior Court. When DUI occurs, usually driver license is taken away and people receive a pink temporary driver license, which is good for 30 days. And not everybody is paying attention that within 10 days you must request the DMV hearing. And if you don't request the DMV hearing, then there is a possibility you might lose it. I mean, you will lose the driver license if you don't contest it. A lot of times with the DUI incidents, police officers must follow strict procedures. And that procedures consist of two tests, which is subjective and objective tests. Subjective tests are field sobriety tests. You probably have seen the guys walking on the side of the road, and people touching their nose, they're walking straight line, and those tests are very subjective. And the reason it's very subjective, a lot of times my clients coming into me and they're saying, look, I passed all these tests and I did everything right. I don't see any problems of losing the driver license. And a lot of times us criminal defense attorneys who do practice DUI, we give free consultations. And I tell my clients, look, I'm pretty much sure that you passed it and you did everything fine. However, that's not what the police officer is going to write on his report. And unfortunately, a lot of the police reports are just similar. They're stating red bloodshot watery eyes, strong odor emitting from of alcohol emitting from the vehicle, and it might be the case that a person has a red bloodshot watery eyes, but it doesn't mean it comes from the alcohol. It could come from work, it could come from staring at the computer, it could come from sitting in a smoky place, but cops, police officers try to interpret it as signs of symptoms of being intoxicated. A strong odor of alcohol also is very subjective. Did the officer smell it, or he assumed it, or maybe there is even an open container in the car? But even if there is an open container, it doesn't mean the driver drank from it. The second aspect of it is, and that people overlook it, that the key is driving while intoxicated. And usually a person gets charged with two counts: driving with while being intoxicated with alcohol or drugs or combination thereof. It's called 23-152A count, and 23-152B count is driving with a blood alcohol level 0.08 or higher. But the key operative word is driving. Even if a person does the breathalyzer test or blood alcohol test, it might be 0.08. But let's say, for example, if it's 0.08 and person just had a drink, blood alcohol tends to rise in the body system, then it reaches the plateau, and then it gets eliminated. And when it and if 20 minutes later, after the person was driving, his blood alcohol level, let's say 0.09, he's being charged. However, because of the body absorption of alcohol at the time of driving, it had to be less. And therefore, these driving under influence cases are very defensible. But it's very important to consult a criminal defense attorney, and hopefully consult someone who specializes with the DUIs. There is a big community of us who do these cases all the time, and not only we are capable of defending those cases. Most of us were certified in field sobriety test administration, like I am actually certified. We're certified in administration of breathalyzer alcohol. Then, even with the breathalyzer alcohol, it needs to be properly calibrated. It needs to be properly maintained. And if it's not, then the results are unreliable, and these cases should be defended. Unfortunately, people think that, oh, okay, well, it's my first DUI. And a few years ago, you don't need to install ignition interlock device. Now you do. Law changes all the time. At some point, it used to be prior, and DUIs are actually priorable offenses. At some point, it used to be 5 years, and then it used to be 7. I still have clients coming over to me and saying, look, I had my DUI 7 years ago, it should be off my record, and I'm being charged with a second DUI. And no, it's 10. And laws changing, and they make it tougher and tougher. And in California, Los Angeles County, if there is no accident and it's a second DUI, it's a mandatory jail time, 96 hours. It's just mandatory. You cannot, in order to not to go to jail, you have to change to lesser included offenses like wet reckless or drive reckless driving. This is in Los Angeles County. In Riverside County, in Ventura County, the laws are different. They're giving minimum 30 days in jail, 60 days in jail. And people do go to jail if it's not tended properly. Like I already stated, most of the DUI defense attorneys do give free consultations. And I usually tell my clients, if you don't take anything from this consultation, then you take one thing, and one thing, you need to be defended. If you can't afford an attorney, you are entitled to have a public defender at your side. And a lot of public defenders are very good attorneys who will defend you. But DMV, on the other hand, there is a problem because it's an administrative proceeding. And with the Department of Motor Vehicle, you're not entitled to have a public defender to represent you. You'll have to represent yourself. And in this case, in Department of Motor Vehicle, it's tougher to fight because the standard of proof is by preponderance of evidence, meaning 51% to 49%. They have to prove that you're guilty of such charged offense. The problem also with the Department of Motor Vehicle is that the hearing officer becomes prosecutor and a judge in the same capacity. And unfortunately, you all know that Department of Motor Vehicle is a highly bureaucratic organization. And to not convict someone in driving under the influence, it's a big responsibility that one must take upon himself or herself. And even though they are great hearing officers, there is some who just not responsive. And our job is not only to defend you in front of those hearing officers, but we also have to give them enough reason to keep you giving driving privileges. It cannot be ignored, because if someone does not do the DMV hearing and ignores it, people might lose their driver license until all the programs are being completed. And a lot of people don't realize that they're saying, well, they took away my driver license, but it's not plastic per se that gets suspended. It's actually suspension is driving on the roads of California is being suspended. And it's in California, to drive in California, it's not a right. And it's a big misconception that it's a right. No, it's a privilege that is afforded to us because we're good people, we pay taxes, we pass the required tests. But it's a right. It's a privilege to drive it. And if we don't have it, second DUI is much stiffer offenses. Third DUI, it's tougher, and fourth it becomes the felony. Then people, unfortunately, I had to deal with a case where a person was convicted of DUI, ignored it. I went to school and was charged and of murder because during his second driving event, someone got killed, and our client, I was working for a big firm at the time, got charged with the murder in the first degree, and the reason he was charged with the murder in the first degree because when he took the conviction, the first DUI, he didn't think nothing of it. But one of the laws that been read to him was, look, if you drive on the roads of California and someone dies because you're drunk, then you will be charged with the crime of murder. He ignored it. He didn't pay attention to it, and no attorney explained to him that it's a true consequence. And we end up going to trial in this matter. We had to prove that no, he was not told that that advisement was given to him. So it might also reflect negatively on the work record. If you are operating commercial equipment, you might lose that, and most of the time the people do lose it. If it's a misdemeanor, first offense, second offense, if there is no injuries, it's a misdemeanor. But nevertheless, a misdemeanor that is staying on the record, and sometimes it could reflect negatively upon employment, upon school, upon licensure, and if not taking care of it properly, it will reflect negatively on your life. There are certain tests that police officers are doing, like such as when they pull you over. Don't forget, the officers need to have reasonable cause to pull you over. They cannot just pull someone over for no reason, just because it's 2 o'clock in the morning. They have to have a reasonable cause to do so. For example, weaving within the lane, or any other violations of driving too slow. Believe it or not, speeding was recently included as a sign of alcohol intoxication. Before, I believe 2009, it wasn't even included as a subjective signs and symptoms of alcohol intoxication, because usually it's slow driving, some abnormality, or speed traps. Speed traps could be done. For example, a lot of people assume that 101 freeway speed limit is 65 miles an hour. So what commonly California Highway Patrol does in this section between downtown and 170 freeway, it's actually 55. There is 2 signs which normally no one sees. And what they do, they know that Saturday night, there's 3 o'clock in the morning. Chances are very, very high that if you 3 o'clock, 2 o'clock in the morning driving on this highway and you're going 65, you're probably coming from a nightclub or going to some kind of party. Chances are high that you're intoxicated. So they just pull you over. And yes, this going over speed limit, even by 10, is enough for them to pull you over. So when you're in the situation like this, you have to be courteous to police officers. You don't have to be argumentative, because believe it or not, argumentative could be signs and symptoms of alcohol intoxication. Okay? Alcohol by itself, it's a central nervous system depressant, which means it slows down your systems. That's why, like I said, slow speed could be sign of intoxication by alcohol. If you're going too fast, it could be signs of drug enhancement, and someone took drugs like speed or cocaine, because everything, the system, everything goes faster, and people calculate, count faster, everything is done faster. So be courteous to a police officer. Do not remember one thing: officers are on the job, and every stop they make, they might not live through it, because they don't know who they're pulling over. And unfortunately, recently, you all watch news, and different attacks happens on police officers. So be courteous. You do not have to do all those tests. Officers are asking you questions. You don't have to tell them anything. You just don't. All those questions are so-called pre-custodial interrogation. And officers are asking you questions. They're trying to be courteous to you, but with the same token, sometimes they're tricking you. Because until you're not free to live, and usually, if you probably all seen in the movies, they're giving you Miranda rights. Those rights are attached only when there is a custodial interrogation. Before that, those rights do not attach. So a lot of times my clients tell me, oh, he didn't read me my Miranda rights. And I told them, look, you probably have seen the movies, Miranda rights are really given to a person only when they're being handcuffed. Before that, those rights do not attach. So it's called pre-custodial interrogation. So they're allowed to, they check you, they're allowed to ask you questions. And plus, you know, it's much easier to catch flies with honey than with everything else. So that's what they do. Then, if you refuse the test, a lot of times officers are asking you to do PAS, called preliminary alcohol breath device. And when basically, you probably have seen, it's a handheld machine that gives by the car, and someone blows into it. What it does, those are unreliable if not properly maintained, and those are voluntary tests. You don't have to do that. And in fact, officers should inform you that you don't have to do it, but they never inform you about that. So common trick is that the officers use is, look, you passed those tests, you did so good on those tests, but I'll tell you, I just need to just blow into this thing, and if it's less than 0.8, then I'll let you go. And if it's more, unfortunately, I'm going to have to arrest you. And people do that. And people blow into those breathalyzer tests. But there is a system by which officers pretty much know when they administer the test, the breathalyzer test by the car, preliminary alcohol screening device. They already know, they already estimated that your blood alcohol level should be within 0.10. And it's done by horizontal gaze nystagmus test. It's done by walk and churn test. It's done by a variety of tests that is administered. But those tests are voluntary. You do not have to do it. California, however, the Department of Motor Vehicle has a law called a refusal. And what happened is you are obligated to provide the test. And but not by the car. You're obligated to provide a test at the station if you're arrested, and then you should give a test, or a blood test, which should be done by a registered nurse or a healthcare professional. Sometimes officers take person to a station or to the hospital to do this test. That test also must be done. Alcohol cannot be used to clean the vein, for example, if they do the blood test. So that test must be given. Well, again, must be given. If this test is not provided at the station, evidentiary test so-called, then a person might get their license suspended up to a year in California. Driver license privilege would be suspended by Department of Motor Vehicle up to a year. If that evidentiary test, not preliminary alcohol screening test, evidentiary test, blood or breathalyzer at the station. So let me just finish. That's why when you get pulled over, be nice to officers. But there is voluntary test and there is subjective test. Again, the field sobriety test is a very, very subjective test. It's what officers perceive. Some officers might say you were swaying an inch, but you might swaying on 3 inches, even worse. I have cases where we got the video, because a lot of times officers' cars are equipped with audio video equipment, where officers showing my client, and it was so windy, where my client performed the field sobriety test better than the officer who showed it to him because of the wind factor. But the officer didn't put it down. The surface must be even when they do walk and churn test, because that's unfair. Or a lot of times, especially for female drivers, they're wearing high heels. and those high heels might prevent it from giving an accurate test. So, and then person might have health problems. They have a difficulty with the balance to begin with. They might have, a lot of times, people who suffer from diabetes, they also on order of someone having a diabetic problem, or could be confused by officers as being intoxicated, and people do get charged with it. So that needs to be addressed, and it needs to be addressed via the attorney. No, it could be private attorney, but or at least public defender.